This walk through history is not an attempt by this court to take on the mantle of historians. The discussion demonstrates that the institution of marriage has not remained static or stagnant. To the contrary, it is change which characterizes the institution. All social institutions transmogrify with time, and marriage is no exception. From sati and widow remarriage to child marriage and intercaste or interfaith marriages, marriage has metamorphosed. The institution as we know it today would perhaps be unrecognizable to our ancestors from 200 years ago. Despite vehement opposition to any departure from practice, the institution of marriage has changed. This is an incontrovertible truth. Here it is also important to take note of the fact that these changes were brought about largely by acts of parliament of the legislatures of the states. While the passage of many laws was preceded by significant social activism, it was the legislature which ultimately responded to the call for change. Even as parliament and in some cases the courts expand the liberties of the people to conduct their lives in a manner they see fit in accordance with law, many sections of society remain opposed to these changes. Regardless of such opposition, the institution of marriage has undergone a sea change. It is therefore incorrect to characterize marriage as a static, stagnant, or unchanging institution. Fundamental rights are not merely a restraint on the power of the state, but provisions which promote and safeguard the interests of the citizens. They require the state to restrain its exercise of power and create conducive conditions for the exercise of rights. If such a positive obligation is not read into the state's power, then the rights which are guaranteed by the Constitution would become a dead letter. This is because the question of whether the state is curtailing the rights of citizens would only arise if the citizens have the capacity and capability to exercise such rights in the first place. The withdrawal of the state from the domestic space leaves the disadvantaged party unprotected, since classifying certain actions as being private has different connotations for those with and without power. In the case of personal relationships which are characterized by inequality, the actions of the more powerful person gains immunity from scrutiny and a degree of legitimacy. Thus, all activities in the private space dealing with intimate choices must not readily and blindly be categorized to be beyond the scope of the state's regulation. The state must assess if its interest in democratizing the private space overrides the interests of privacy in a given situation. In pursuance of the power conferred by Articles 245 and 246, read with entry 5 of the concurrent list, Parliament has enacted laws creating and regulating socio-legal institution of marriage. The state legislatures have made amendments to such laws with the assent of the President, since the subject of marriage is in the concurrent list. The petitioners seek that the court recognize the right to marry as a fundamental right. As explained above, this would mean that even if Parliament and the state legislatures have not created an institution of marriage in exercise of their powers under entry 5 of the concurrent list, they would be obligated to create an institution because of the positive postulate encompassed in the right to marry. This argument cannot be accepted. As explained in the previous section, the state through the instrument of law characterizes marriage with two constituent elements, the expressive component and the material component. Marriage may not have attained the social and legal significance it currently has if the state had not regulated through law. Thus, while marriage is not fundamental in itself, it may have attained significance because of the benefits which are realized through regulation. If the court finds that a provision is contrary to Part 3 of the Constitution, it shall declare that it is void, or read it down by deleting phrases, or read words in by adding or substituting phrases to save it from being declared void. If in the present batch of petitions, this court holds that Section 4 of the Special Marriage Act is unconstitutional because it is under-inclusive to the extent that it excludes, by implication, marriage between same-sex couples, the court would either strike down Section 4 of the SMA or follow the workability model submitted by the petitioners. If the court follows the first approach, the purpose of a progressive legislation such as the SMA would be lost. The SMA was enacted to enable persons of different religions and castes to marry. If the SMA is held void for excluding same-sex couples, it would take India back to the pre-independence era, where two persons of different religions and castes were unable to celebrate love in the form of marriage. Such a judicial verdict would not only have the effect of taking the nation back to the era when it was clothed in social inequality and religious intolerance, would also push the courts to choose between eradicating one form of discrimination and prejudice at the cost of permitting another. If this court takes the second approach and reads words into the provisions of the SMA and provisions of other allied laws such as the Indian Succession Act and Hindu Succession Act, it would in effect be entering into the realm of the legislature. The submissions of the petitioners indicate that this court would be required to extensively read words into numerous provisions of the Special Marriage Act and other allied laws. The court is not equipped to undertake an exercise of such wide amplitude because of its institutional limitations. This court would in effect be redrafting the laws in the garb of reading words into the provisions. It is straight law that judicial legislation is impermissible. We are conscious that the courts usually first determine whether if the law is unconstitutional and then proceed to decide on the relief. However, in this case, an exercise to determine whether the SMA is unconstitutional because of under-inclusiveness would be futile because of the limitations of this court's power to grant a remedy. Whether a change should be brought into the legislative regime of the SMA is for Parliament to determine. Parliament has access to varied sources of information and represents in itself a diversity of viewpoints in the polity. The court, in the exercise of the power of judicial review, must be careful not to tread into the legislative domain. It is clarified that this court has not adjudicated upon the validity of any laws other than the SMA, the FMA, the adoption regulations, and the CARA circular.